Good afternoon, everyone. My name is Vignesh. I'm a practicing advocate currently in Delhi. And today's webinar is about uh, how to draft and how exactly to go about in a check bounce case. So that's the most important aspect as a starting lawyer. Many a time you're going to come across check bounce cases. You're going to come across several cases pertaining to when debts due exist and there is a check issued towards such debt, and the check is bounced upon presentation towards discharge of that debt. That is the main basis for a check bounce case. So in today's class, we're going to have a discussion on three very important points with respect to check bounce cases. Firstly, how to proceed with issuing of notice and filing of complaint in a check bounce case. The second is how to proceed with a check bounce case. And third is the important factors for consideration in a check bounce case. So these are three parts that we will be touching upon during this webinar. Sure. The second one is how to proceed with the check bounce case. Hope that clarifies, Siddhant. So continuing ahead, the first and most important thing that you need to do when you hear anyone who comes to you with a complaint of check bounces, that it's important to realize that the check has been issued towards discharge of a debt. All right. The most important thing in check bounce case is that the check was firstly issued towards a debt. If there exists no debt, then the check issued will not be liable to proceedings under Section 138 of the Negotiable Instruments Act. That is something that many people do not realize, especially in their notices. And that is something that you must be absolutely aware of and ask your client regarding. For example, if I issue a check to say a friend for 50,000 without it being a debt, and the check bounces, there may be a basis for a check bounce case. But if it cannot be shown that the amount was paid towards a discharge of debt, then the case would not be maintainable in the first place. The second and most important thing that anyone has to know about in a check bounce case is the time periods. All right. It's exceptionally important to know what the time periods for issuance of notice and for filing a complaint in a check bounce case are. And that is of primary importance because if you miss those deadlines, then they can be fatal to your case. So if a check has been returned for insufficient funds or any such similar reason, which forms the basis for your check bounce case, you should firstly send a notice for the check having bounced within 30 days of the occurrence of such check bounce. All right. First, importantly, a notice has to be sent within 30 days of the occurrence of a check bounce. Now, if the draw has failed to make the payment due within 15 days of receipt of the check bounce notice, or demand notice as it's called under Section 1, as per the Negotiable Instruments Act, then a complaint requires to be filed within 30 days from the date from after the period when he has received the notice and failed to discharge his debt. So those are your very important timelines in a check bounce case. They commonly refer to as 30, 15, 30. Very easy to remember it. 30 days from the date of issuance, from the date of check bounce, a demand notice has to be issued. Within 15 days from the date of receipt of such notice, the payment has to be made. In the event payment is not made, then within another 30 days from that date, your complaint under the Negotiable Instruments Act should be filed. So that is the first and foremost important aspect that you must know about for a check bounce case. The other aspect that you should definitely know about is who to implead or who to send the notice to. So it's always towards the person who has failed to discharge his debt and had issued a check in that regard. It's quite simple when it comes to any individual person. All right. Say it's two persons, A and B. A issues a check to B towards discharge of debt. The check bounces upon presentation by B. Then there would be a notice and a check, and thereafter, if the time post the timelines having elapsed, there would be a complaint under section 138. Now, there exists a curious case of what happens if the check is issued by a corporate entity, because more often than not, a corporate entity may issue a check. In those situations, it's important to realize who you have to send a notice to in the first place, so that thereafter the proceedings can be initiated not only against the company but also against such persons. And the reason why you do it is because of the remedy that check bounce cases give you. So it ensures that the person is paid back up to twice the amount of the check, or he may face punishment with imprisonment for a period which may extend up to 2 years. Now, the payment aspect can be taken care of by a corporate entity. But let's assume that you want imprisonment if they are convicted of check bounce case. You can't put a corporate entity behind bars. So you will have to put some person of the corporate entity behind bars in the event there is a check bounce offense by a company. So generally, it is considered that any person who is responsible for the conduct of the business of the company shall be deemed guilty of such offense. And this is provided for in section 141 of the Negotiable Instruments Act. And in reality, what it means is the person who generally signs the check on behalf of the company is deemed to have committed the offense or will be charged along with the company. And the second thing that is very important is any person who is responsible for the day-to-day affairs and conduct of the business of the company. So all such persons would be responsible for the notice being sent to, in addition to the company in a check bounce case. So just to give you a very quick hint, suppose the managing director of a company conducts the day-to-day affairs, you need to be aware of it. Rather, the person who's filing the check bounce case needs to be aware of it, that he was the one conducting the day-to-day affairs of the company. Say the accounts officer has signed the check, and both these activities are being done on behalf of the company, then you have to ensure that the notice is sent to not only the company, but also to the managing director and the accounts officer. So the notice has to be issued to all these three people to ensure that the check bounce case will be maintainable. So that's how you need to file a check bounce case against a company. It's very important to realize that it's not only important to send the notice, but you send the notice to the right people. So that's pretty much all that you need to know when it comes to the timelines for a check bounce case and to whom notice is issued. Quick recap: if there's a private entity, say a person is what I mean, then it will be issued, the notice will be issued only to the person. If it's an offense having been carried out by a company, all right, then you issue the notice not only to the registered office of the company, but you also issue the notice to the person who is in charge or who conducts the day-to-day affairs of the company, as well as the person who signed the check, if it is not the person who conducts the day-to-day affairs of the company. So those are the several people to whom you send the demand notice in a 138 complaint. Hope that clarifies to all those who have a doubt. Now, we come to the next aspect of how to deal with a check bounce case when a client approaches you. So the first thing that we need to ensure is having not only drafted the notice, but have it served on such person. For example, uh, if it's very important for your client to help you understand or furnish the right address to which the notice is to be sent to. It's not just that the notice is sent out, but the notice should be delivered to such person. All right. It's not just enough to send out a notice within 30 days. It has to be received by that person as well. Otherwise, he is not aware of the threat that he is facing and the demand notice that has been raised by you. So it's always important to identify the address of the accused. Generally, it's quite clear what the address is. It's important that the notice is served at his address, and it can be in a variety of ways. The most common way in which it is done is registered post acknowledgement due. In the event that such person, flits through houses or keeps traveling on business, you can also serve by hand. But if you do serve that person directly, you need to have a second, probably a Xerox copy of that demand notice, and get his countersign on the copy of the demand notice to say that he has received it on such and such date with his signature, and ensure that you keep that copy with yourself, either in your office, or keep it, or instruct your client if he is doing the service to keep a copy of that and give it to you, so that you have proof of having served such person the demand notice. Now, there may be situations as well where people send demand notices by email. Unless there is regular correspondence to prove that that email is in fact being used by the accused, it would not be deemed as a sufficient service of notice until and unless that either there's a receipt received from that person that he has received such notice, or that the email ID is being used for regular correspondence. The latter point, that is the email ID being used for regular correspondence, may still be moot as to whether he's received it or not. Proof of receipt is only upon acknowledgement, and there has to be a record of such acknowledgement. That's the very important aspect about the service of notice. So you can send by courier, but you need the tracking details to show it has been delivered. It's usually registered by register. It is usually sent out, by registered post acknowledgement due. And in the event that it is sent by that way, you can get the postal receipt delivered to you, and you can also have it printed out from the India Post website, one through the tracking of that specific postal delivery. Similarly, if it is against companies and persons associated with companies. So it's very important not only to have served the notice, but to ensure that you have a record of the proof of such service of legal notice. Now, we need to get into the aspect of how to draft a legal notice, because that's a very important aspect when it comes to Negotiable Instruments Act case. So what I'm going to do right now for the next 15 to 20 minutes is I'm going to share my screen and a draft of a 138 or section 138 demand notice, and take you guys through what are the prerequisites to a demand notice issue. So I hope all of you can see this. So you can have generally any which way. It need not be by an advocate always, though it is generally done by advocates. It can be by an in-house counsel as well on his company's letterhead, and it is sent out to the other parties. If there are more than one party, so you'll write 1, 2, 3, so on and so forth, and show all the parties who should be served this legal notice. So the legal notice will generally be just one, but depending on the number of parties, you may have to duplicate it and serve it on all of them, either separately or jointly, depending on their addresses. Then you have to stipulate the date. It can be right here or on the right hand side over here. No problems whatsoever. That's up to you. And you may give a subject to the letter or the notice, not necessary. And you draft out your notice stating that you issue this notice on behalf and in the instructions of your client. State your client. You can, if it's an individual, you generally say son of, daughter of, wife of so and so, aged so and so, residing at, and his address, and state that we have been notified to inform you as follows. If it's on behalf of a company, you will just state your company along with the address, and thereafter you state that we wish to notify you as under. And thereafter, the important aspects of what your demand notice should say is that uh, a check was issued towards discharge of debt. That's the first and most important point that your demand notice should state. And these are the prerequisites, the essentials, that when the check was due, the check was in fact presented before so and so bank, and uh, upon presentation, it has been returned along with a memo from the bank stating that the funds were insufficient or whatever is the discharge memo given by the bank. Okay, even a cancelled check may result in a negotiable a case of 138 filed, depending on the situation. And thereafter, you have to inform the other party that you herein demand for the payment of such amounts within 15 days from the date of receipt of this notice that you're sending him, which forms part of, which is the basis for your claim. So at this juncture, I will just quickly look through the chat box to see what doubts people do have. So I've been asked once more about throwing light on the limitation aspect of a check bounce case. So from the date of check bounce, within 30 days of such date of check bounce, you need to issue a legal notice or a demand notice as it's called. And if the accused wants to discharge the debt, he is given 15 days from the date of receipt of notice to discharge that liability. In the event he does not discharge his liability, then within 30 days post those 15 days, a 138 complaint or a check bounce complaint requires to be filed. So those are your important timelines insofar as check bounce cases. Secondly, as I said, in respect of your notice, it's not enough to just say that a check was issued and that check is bounced. You need to give the particulars of the check. So more often than not, there'll be a check number at the bottom. There'll be a date for the check, and the check will also have the details of the person who has signed the check. And it will also mention the account number and the account holder of that specific account on the check leaf. So all these details require to be included as prerequisites in your demand notice. Okay. So I'm just going to quickly go through the notice. I'm not going to be reading part by part of it, but what I will do is bifurcate the notice into the various aspects which are prerequisites in such a notice. So it's common for advocates to state the particulars, the brief particulars, or a brief description of the parties. You may state that my client is a company incorporated and registered under the Companies Act, or you can say that my client carries on business in this regard. You can give a brief description of your client, and thereafter you can also give a brief description of the accused. You can say, you are engaged in the business of so and so, in the manufacture of tiles, anything that you so wish to state. Thereafter, you need to state out the particulars which form the basis for the demand notice. That towards a discharge of debt, you had approached my client and placed orders for so and so, or sought for a loan amount of so and so, depending on the situation and the particulars therein. You have to specify how exactly the transaction happened. So, apologies, am I back online? Can all of you hear me? I think there was a power cut at my end. Hope all of you can hear me. All right, continuing. Continuing, you need to, state uh, the nature of the transaction which result in the occurrence of that debt. Post which you have to state that towards the discharge of the debt occurring owing to a transaction, to a loan, to the nature of whatever amount was due in debt, uh, the accused had, issued a check bearing so and so, dated so and so, for a sum of so and so. All right. You can also state it this way. So over here you have check number, date, amount drawn on. And you will also go on to state that based on the assurances that you have received from the accused, you had presented the check towards discharge of debt or liability, only to find that the check has been returned with an endorsement by the bank stating funds insufficient or any other uh, you know basis which forms or is stated by the bank. So here you see that the bank has given a memo stating drawer's signature to operate account not received. Okay, so thereafter you will have to state that you've got this return memo from the bank, and this constitutes the basis for the legal notice for dishonor of check. That, and thereafter you can state that uh, you know you request them or you demand that they make the payment within 15 days from the date of receipt of this uh, legal notice, and in the event that they do not make payment within this time period, they will be liable for consequences resulting therefrom, including a case under section 138 of the Negotiable Instruments Act. So that is exactly what needs to be conveyed in your legal notice, and that's what your last paragraph will also be about. What kind of a notice you will file, or what kind of proceeding you will file. You may say that we may file case having both civil and criminal consequences, the costs and consequences of which your client is liable to bear. That can be a statement as well. You don't need to explicitly state that I intend to file a 138 notice, or this notice has been issued pursuant to the provisions under section 138 of the Negotiable Instruments Act. But the notice will be considered as, it has to clearly ask for the debt back, and it has to state that the amount due is in fact a debt to constitute that it meets the essentials for a check bounce case. So that is what your notice requires to state. All right, then you're going to wait. Post that, ensure that the 15-day timeline is there, and you see if the other party gets back to you and makes the payment. If the payment is done without interest as well, then that concludes the discharge of debt. If you enter into any settlement agreement towards the discharge of debt, the adjustable sum payable, if paid, would constitute a discharge of debt, and there can be no case under the Negotiable Instruments Act for the check bounce case once the debt has been discharged, as per the agreement of the parties, irrespective of what the check amount is. Now, in the event that the debt isn't discharged, then you need to file a complaint. Okay, the complaint will be filed before the appropriate magistrate, as the case may be, and it's very important to ensure that the essentials of a complaint are met. So, just to give you an idea of what your essentials are, The essentials are that you need to ensure that you satisfy all the conditions for a negotiable instruments act case to be maintainable, and it has to be given along with the check. So when the check, why it's called a check bounce is because the check which has been given by you or presented to you to the bank is in fact returned by the bank with a memo of the basis why it could not discharge the amounts due and payable as per the check. So you need to present the check along with the memo, as well as you need to produce all documents which form the basis for you to state that the check was issued towards a discharge of debt. So more often than not, the check can arise towards payment from a commercial transaction. That there were paints, there were tiles which were delivered to you. So it's very important that you ensure that you're able to prove beyond reasonable doubt that not only did you receive a purchase order, but you were also able to satisfy or give the raw materials, and you have proof of the sale of goods or the provision of services without there being any dispute in either the quality of the good or service, or that there is absolutely no dispute with respect to discharge of debt. Because if there is any dispute towards the discharge of the debt, that can form the basis for a case under Negotiable Instruments Act to be thrown out. So I've been asked questions in the chat box as to what is the remedy that a person can have if the check is dishonored and he hasn't taken any legal action for many years. Well, it depends on how many years, to be honest. So if your check has been dishonored and there isn't further action taken within 30 days to send out the legal notice, what many times people can do or possibly have done is that they represent the check if it is within the first 6 months from the date of issue of check to get a further memo saying that the check is bounced, and then they can present it. But that can't be done for many years. It's usually done within a 6-month period when the check is valid. In the event that fails, then you can still file a civil suit for recovery of the sums due and payable within a period of 3 years from the date of cause of action. But that will have nothing to do with a dishonor of check, and that is something that I probably will not be dealing in detail in this class or this webinar, to be precise. So yeah, in the event that you do not want to proceed with a check bounce case, your alternate remedy is that of a civil suit. The time period for filing a civil suit upon towards any amounts due and payable under uh, any amounts of money payable is 3 years, okay, from the date of cause of action. So that's the most important aspect that you need to know when it comes to what are your remedies available in the event of check bounce. It can be under Negotiable Instruments Act, which would be under the Criminal Procedure Code and before a magistrate, or it can be before the equivalent of a district judge or an additional district judge, as the case may be, in the district court for the purposes of a civil suit. So those are the two possible remedies when a check bounces in the first place. Now, the important question that I'm now receiving is how do we draft out, a 138 complaint? So we will be dealing with that right away, and I will quickly just share, a 138 complaint that we have, or that I have for you guys. So very important aspect is to file it in the right court. All right, you will always file it in a magistrate, before a magistrate, or an additional magistrate, or a metropolitan magistrate. Depends on where you are. Judicial magistrate, first class, second class, as the case may be, and depending on the amount. So it has to always be in the court, having the lowest court having jurisdiction to try the matter. That is why you file your negotiable instruments complaint. Thereafter, you have to state the police station. So the place where you presented the check can be the basis on which you proceed to file your complaint before the magistrate, the court, the court having or the jurisdiction in the area where the check was presented. That would constitute as the basis for your complaint. And what you need to really remember here is that uh, you need to state the particulars of how or what basis you file your complaint. So you need to most importantly state that your complaint is uh, being filed towards the discharge of a debt. So you give, as I explained in the notice as well, a brief explanation of what the complainant does and what the accused is engaged in the businesses of, whether they are companies, proprietors, so on and so forth. And uh, that's pretty much what you need to state for your introductory paragraphs. The second part that you need to state is the basis for the complaint. So you will have to show that there was a transaction or there was a business or there was a loan or some sort of a transaction which formed the basis for the existence of a debt due to the complainant by the accused. So that is what you will be describing. That will be as per what your client generally tells you was the nature of the transaction. You will probably be representing the complainant. So you will have to be made aware of and appropriately draft it with your client's instruction and expressly state the existence of such debt, that the check was issued towards the discharge of the debt. It can be towards a partial discharge or a complete discharge. And you need to state the particulars of the check, that is the check number, the date, and upon which bank it was drawn on, and the branch as well, and before which bank you went and tried to discharge the debt. More often than not, you will state the bank name and the branch of the place where you presented the check for realization, and uh, what exactly was the memo that the bank had given you, stating that the amounts as stated in the check cannot be realized, and the reasoning for the same. Then you will have to state that you sent a legal notice. So all the aspects with respect to legal notice will come next. You will state that you've complied with the provision of section 138, that you've sent a legal notice to the accused and confronted him regarding the check having bounced and legal consequences associated with the non-payment of dues owing to the check having bounced. And depending on what was the statement made by the accused, you will also state that here. You may not have a record of it in paper, but he may have either orally told you that I'll discharge it, or he may have made a written communication to that effect, depending on the situation. And thereafter, you'll have to state that. So you'll have to not only say that you've issued a notice, but it was received by the accused on such a such date, and have necessary documents in that regard. That is your legal notice, along with the postal receipts, as well as the postal slip received by the complainant. So the postal slip will state that that's the tracking ID. It will correlate with the tracking ID number is put into the India Post or whichever courier's company which you choose, and it will disclose that the item has finally been received on such a such date by the accused. The contents of the legal notice, or the legal notice. So that will ensure that you've completed with all the requirements that form the basis of a 138 notice. And then you will state that not only has he not made payment so far, but he is also not willing to discharge his debt due, and which has also been acknowledged by him by issuance of a check dated so and so. Okay, and that this is the basis for you to file and prosecute the accused under the provisions of the Negotiable Instruments Act. You will also state the cause of action and how this court has jurisdiction and the documents that you file along with your complaint. You will thereafter seek your prayers, that is, you will ask the accused to be summoned by court for having committed, and you will also request that he be tried uh, as per the provisions of the Negotiable Instruments Act with respect to the offense that he has committed, and direct the repayment of the amount due in debt along with interest, or as per the Negotiable Instruments Act, up to twice the amount due and payable by him with justification. All right. So you generally do not state that you ask for imprisonment here. You generally want him to be sentenced or held guilty of the offense under Negotiable Instruments Act. Thereafter, sentencing will be done by the appropriate criminal court. Okay. So you don't need to state that hold him liable to be imprisoned for a period of 2 years. That's not the most important thing. The most important thing is that he discharges his debt in a negotiable instruments case. So these are the aspects that need to be covered in a Negotiable Instruments Act complaint filed before the appropriate court. Now, what exactly can be the maximum punishment? I've explained this part to you guys. It's payment of up to twice the amount of the check, or imprisonment of up to a period of 2 years. Now, post presentation of check, there are several things that require to be done. It's not that once you present the check, you present the complaint, that the case ends. In fact, that's the start of the criminal proceedings. Thereafter, you have the proceedings taking place as if it's a summons case. So you can read up the procedure of a summons case under the CRPC. The provisions remain the same. So I'm not going to explain it in great detail, but the first requirement that any advocate is required to do is you have to present the complaint before a magistrate, okay, carrying the originals of the check return memo, the notice to the 138, any reply received in that respect, and also all documents which show the existence of the debt in the first place. Post that, you have what is called a sworn statement, wherein the complainant is brought for examination of the originals of the documents, and thereafter notice is issued for the accused to be present before court. Now, if the accused arrives, then well and good. He will have to enter appearance before the court. If not, there may be either a non-bailable warrant issued, or the court may ask you to furnish a fresh address, as the case may be. So those aspects happen, and then the case moves into trial. All right. So I'm not going to explain in detail or at all about the workings of how a summons case works, because that is not the purpose of this webinar. But this is pretty much the basis of how to handle a check bounce case step by step, from the date when the case is brought to you till the date when you present the complaint before a court. So more often than not, your check bounce amounts due and payable will stand satisfied if you make the payment of the principal amount. All right, the court will not ask you to pay costs of litigation and interest if you're able to discharge the debt due as per the check. But in the event that it reaches the stage where judgment is passed, there may be amounts which are due and payable over and above the check amount, which the court can include or appropriate towards you. Now, what will you do as an accused in such a situation? You do require to ensure that if the three conditions required towards a check bounce case are satisfied, there's nothing an accused much can do. It's an open and shut basis. But there are situations where, especially if you are prosecuting a company, certain accused can be let go of if the complainant is not made aware of or is including them without any basis. For example, if you do not know who's running the day-to-day affairs of the company, then all those persons who are not signatory to the check and who are not the company in itself will not be liable for any reason whatsoever under the 138 proceeding, unless you can show how you've formed the basis to say that he's aware of the day-to-day proceedings or conducts the day-to-day proceedings of the company. So there may be defenses to certain accused, especially in companies, but it's generally a very open and shut case. If the conditions are met, then it's clear that there is a check bounce. So it's always better to try and settle it if you're the accused. Ensure that you make the principal amounts due and payable to close the case. There are, of course, defenses available, so you may also avail those defenses if they suit you or suit your case, as the case may be. For example, if the complaint does not have proof that the notice sent out was in fact received by the accused can always raise that to say that one of the conditions for uh, a check bounce case have not been met, so therefore he may ask for him being acquitted in such case. So that's pretty much the A to Z of how to handle a check bounce case from when you receive such a case to the time you present it before a court. So I've been asked a question as to whether courts entertain condonation of delay in cases relating to dishonor of check. Yes, they do. They do, entertain condonation of delays applications for only the time when the complaint is being filed. They don't entertain a condonation of delay for any other reason. And that may also require to be tried to see if the accused disputes the basis for the delay in filing of the complaint in the first place. That concludes my session with all of you. Does anybody have any doubts? I'd be happy to address them. Any doubts? So I've been asked to share the drafts. I will give these drafts to the concerned person at 𝘺𝘀. The other thing that you can definitely do is you can enroll into the courses which provide, you know, not only how to draft a check bounce case, but also, how to draft a check bounce related legal notice and complaint, but also learn the criminal procedure involved with a check bounce case. I think there's a course in criminal litigation in that regard. I think even the civil litigation course deals with aspects pertaining to check bounce cases. So you can always definitely, you know, get into one of these courses to learn more about not only this, but other recovery methods which can be employed, especially the civil litigation course towards recovery of money. The criminal litigation course will deal with various kinds of issues pertaining to, criminal matters. So that concludes my session today. If any of you have any doubts that can be dealt with, if you wish to, by writing to me, I will give you my email ID in the chat box. That concludes the session. Thank you so much for being such a great audience. Thank you. Bye-bye.